Welcome everyone to the event Arbitrating IP Disputes, How to Anticipate and Manage Them. This panel is hosted by the Silicon Valley Arbitration and Mediation Center and Fox Williams. My name is Sarah Lee. I'm an International Disputes Associate at Debevoise Plimpton in New York and a member of the SVAMC's Law Firm Coordination Task Force. It's my pleasure to be moderating this discussion today. I see we have lots of participants and trickling in. But before I introduce you to our esteemed speakers, I'd like to briefly pass the mic to Les Schiffelbein, who's the CEO of the SVAMC, for some welcoming remarks. So Les, on to you. Les, I think you're on mute.
I think Jessica put me there. Well, good morning. Thank you, Sarah. And I must say I'm very happy and excited about the webinar this morning. And in particular, I'd like to thank Fox Williams for partnering with us, and Ben, you in particular, for you and Jonathan Fitch having the great idea to move forward with this webinar. And a few other thank yous. Sarah, thank you for being a moderator this morning. Okay. And we have Ben, James, Luciano, and Simon as your panelists. I hope that you pepper them to death with, well, maybe not to death, but you pepper them with intriguing questions on intellectual property. It's a great subject, and one that, if I follow in my language, bedevils a lot of individuals. Particularly when you know something's on the horizon, and then you have to deal with it. I don't see his friendly face right now, but I'd like to thank Jonathan Fitch. Jonathan is the chair of the law firm task force, and this is one program in a series that he and his team have presented. And also I'd like to thank from Fox Williams, Jessica Bennett, for helping us out so much, and from Silicon Valley for Annie Keating in marketing the program. And just one last word about Silicon Valley. For those who might not be familiar with us, we, unlike arbitration institutions, we don't take cases. We are singularly a nonprofit which advocates alternative dispute resolution in the technology sector. And over a few short years, we've grown much like a Silicon Valley venture firm, from a few members to having a very wide global footprint. And we're very happy about that. If you'd like to learn a little bit more about us, svamc.org. And Sarah, back to you, and looking forward to a great program. And thanks again.
Thank you, Les. So I guess I'll try to pepper the panelists with lots of bedeviling questions. But before I do that, I'd like to very briefly introduce our distinguished speakers for today, and starting with Ben Giaretta, who is the co-head of international arbitration at Fox Williams. He is a commercial disputes lawyer with a broad range of experience in litigation, mediation, and expert determination. He has a particular expertise in international commercial arbitration. He also serves as the chair of the London branch of the Chartered Institute of Arbitrators, and he's been appointed as arbitrators on many occasions. Now resident in London, he's also spent many years living and working in Singapore. Next, we have James Hargrove, who is a partner in Orrick's International Arbitration Practice Group. He is based in London and Geneva. He has over 20 years experience and has acted as counsel in over 70 international arbitrations. James has a particular specialization and interests in arbitrations concerning tech sector companies, including disputes relating to IT and IP, telecoms, data, licensing, and a wide variety of corporate and investment disputes. Next, we have Luciano Filippi, who is the head of legal at INEOS Technologies and Catalyst. He has broad international experience in legal affairs and has worked with several large global corporations with an emphasis on technology development and licensing in the chemical and petrochemical industries, originating, among others, from BP, BASF, and Shell. Luciano has worked extensively with IP issues and technology transfer, both as a technology provider and as a technology buyer, joint cooperation projects, and international joint ventures. He's held management positions in the Netherlands and the UK, and he's dedicated extensive time to reshape and optimize governance, compliance, risk management, conflict prevention, and resolution for INEOS technologies and Catalyst. Last but not least, we have Simon Bennett, who is the head of IP at Fox Williams. Simon has arbitrated IP disputes at various arbitral centers around the world, including ICC and LCIA. And he's also sat as an arbitrator at the Czech Arbitration Court, which deals with brands and trademarks as part of dispute resolution on the .eu GTLD platform. Simon was one of the first to initiate a successful class action domain name arbitration under the UDRP at WIPO for 100 famous authors. So we have a very exciting panel with us. And so let's start our discussion. And I wanted to start with just a couple of broad questions to frame our conversation. And I'll turn to you, Simon, first. So could you please explain to our audience, when we're talking about IP disputes and arbitrating them, what are we talking about? What kind of parties are we seeing? What types of claims are being brought? And do you have any comments on general trends, like certain regions or industries in which these disputes arise more frequently than others?
Thank you, Sarah. Maybe I'll start with the last part first, actually. I think in terms of the types of disputes, what we're seeing in terms of, in fact, I have some statistics here. We have probably about 29%, this is according to WIPO anyway, with 29% of arbitrations that WIPO sees as are patent disputes. And those most commonly concern patent licenses, but also the issue of infringement and the validity of patents, where that's necessary. About 21% of the disputes we see are trademark disputes, and those commonly concern things like franchising, licensing, distribution agreements, and also trademark assignments. There's also quite a body of copyright arbitration disputes that go through WIPO, and those include issues to do with, you mentioned the tech space earlier, the software licenses, sort of tech copyright infringement in the tech space in particular. Those are quite common, and I think in terms of sectors, I'd say the most active sectors in sort of arbitrations at the moment are medical and tech, and I think mainly the reason for that is that a lot of those industries are sort of very multinational, and I think one of the common themes of arbitrations that we're seeing today is that they are international in nature, and they commonly have parties that are from often different continents, not just different countries, and it's where parties are seeking to find a forum for their dispute that's neutral, that's confidential, quicker and more convenient than going to national courts in some countries, and also, most importantly, particularly when you're talking about tech or medical issues, most importantly, that the arbitrators themselves who sit to adjudicate these disputes have the specialist expertise necessary to be able to do so, which you can't always get in some courts and in some of the jurisdictions where the companies may or may not be based. So we're seeing quite a lot of that. And so we're seeing sort of the main, the EU, North America, Asia Pacific. Those are the main regions where we're finding parties coming from, and they're submitting to arbitration, because they know they're going to get a good hearing, and it's a neutral venue. So that's a sort of, I suppose, an overview of where we are at the moment. I think I think tech will continue to grow probably because of its ubiquitous nature, and particularly given the reliance we have on tech, and the increasing reliance we have on tech. Even this webinar is happening via technology. So I think that's going to continue, as will the medical side as well. Another growing industry for obvious reasons.
Certainly so. Thank you, Simon. Now, turning to you, Luciano, today our discussion centers on IP arbitrations of the kind that Simon just described. But as in-house counsel, part of your job is to avoid these disputes in the first place. So I'd be curious to hear from your viewpoint, how do you anticipate or manage these disputes before they even arise, including, for example, when drafting agreements and dispute resolution clauses?
Yeah, thank you, Sarah. Well, the in-house counsel view in avoiding dispute is that this is part of the risk management of the legal department. Primarily, it is a matter to align the business expectations with the contractor rights. However, this is easier said than done because in the technology arena, not all the legal professionals have the technical, the legal, the business knowledge to anticipate all the potential issues. And all these issues are intertwined, and you have to discern all of them. This is particularly relevant for certain contracts under which technology is implemented for example, the construction of a facility operating a process technology, which may require several years for construction. And during this time horizon, several issues and delays may happen, and this should be contemplated in the contract. So the lawyer job, in order to prevent the dispute, is in the end to figure out what is the life of the project, what could happen, what are the friction points, and address all of this in advance contractually, as I said, in order to align the business expectations with the contractor rights. Once you have assessed the jurisdictional and the market risk, you will implement the risk management measures, such as deciding whether to include in your contracts or not an arbitration agreement or a jurisdiction or a choice of court agreement. In IP licensing agreements, the preference goes to arbitration agreement for the reason that Simon just said. Confidentiality, of course, especially if you are a licensor. In the end, you don't want to give resonance to the dispute because obviously you want to continue your business and you want to be seen as a reputable licensor. A neutral forum, and this is very important because when the technology, for example, is licensed in countries where there are established state-owned companies, the rules governing the impartiality and independence of the judges are not harmonized at the standards which we are accustomed in our jurisdictions. Then, of course, the ability of the party to select arbitrators, technical expertise to understand complex issues, as Simon just said. But another two very strong points for the arbitration is the cross-border enforceability of the arbitral awards, and in some jurisdiction, time efficiency, especially in Latin jurisdiction, I must say. And of course, the other point is a centralized dispute resolution, because you can resolve multi-jurisdictional disputes in a single proceeding, and this is extremely efficient from a corporate perspective. Another element, just to link to what Simon just said, is that when you make all these considerations, it is very important to understand the competitive environment where you operate. Where there is a high concentration of technology development and each business is working hard to acquire or extend its market share, and when there is a high demand for such product in the market, you may expect disputes to arise. We have seen this in the petrochemical industries in the 60s, just after the invention of basic materials like plastics. We may see something similar in the near future, for example, in the self-driving car business, in material recycling, which are things of today. In the end, to be honest, there is no real mystery in how we approach the dispute when they actually arise, when differences arise in the interpretation of a contract. First, we approach the matter with a structured negotiation at senior level for an early settlement, because in the end, the business wants to carry on. They're not strictly interested in going into dispute. Potentially, a mediation or an expert determination is considered. However, if all of these attempts do not bring an appreciable result, then we also consider, of course, arbitration, because that is in the end what we have agreed in the contracts.
Thank you, Luciano. It's always, I find it always insightful to look at legal issues in the context of business considerations. And so perhaps turning to you, James. So as Luciano explained, there may be strategic reasons for arbitrating certain types of IP disputes, but taking a step back, could you please perhaps explain to the audience, how do various jurisdictions treat the arbitrability of IP rights in the first place? Do you see any differences or commonalities in how, for example, common law or civil law jurisdictions treat that? And perhaps we could hear some experience from you, given that you are based in both in Switzerland and the UK.
Thank you, Sarah. Thank you, everybody. Yes, what Luciano said was absolutely right, of course. One of the benefits of arbitrating IP-related tech disputes is likely, if you've got some form of international patent portfolio or whatever other disparate IP spread, rather than go to a bunch of national courts, which I'll explain are all different, you can go to one place, ideally. Although it does get a bit more complicated on enforcement of an award that may emanate in one jurisdiction and not be procedurally enforceable in another jurisdiction, notwithstanding it's an international arbitration award, for reasons of arbitrability, which is what I will explain. So on a very quick and selective trip around the world, what users need to be aware of is that there are very different categories of approach to the arbitrability of IP issues. And I'm going to talk about patents mainly. Actually, trademarks are more or less the same. And they go from the supremely liberal, right here in Switzerland, to the supremely illiberal in the sense of IP in South Africa and a couple of other places. So running through the 4 different categories of what you might expect, and you might want to bear in mind if you are an in-house counsel dealing with international arbitration related IP issues. Switzerland and Belgium are the poster entities for arbitrating everything. You can have decisions on invalidity, revocation. Of course, you can have infringement decisions, but you can have those in arbitration, and the arbitrators have the power to procure that the patent register is amended in Switzerland, in both of those countries, which is quite interesting because that's not the case in many countries. Rather more restrictive, for example, are Germany, Italy, France, China, the Netherlands, Sweden. Their matters of patent validity are reserved exclusively to the courts. Of course, infringement, etc., is arbitrable. You have a halfway house, which is familiar to many of those on this call, likely in the UK and the US, Japan, Singapore, where validity of a patent can be decided, but it can only be decided inter partes. There's no erga omnes, as it's so-called, ability to amend the patent register, but there is, of course, infringement arbitrability. And lastly, as I said, South Africa stands out as somewhere where you basically can't arbitrate anything about patents or IP, hard IP at all. So it's important to know those things, and where the interesting challenges arise are not only working with clients to understand how they may best take advantage or deal with those jurisdictional challenges, but also working with your arbitrators to make sure that your relief is effective. It isn't much good if you have a decision on revocation emanating from a Geneva-based arbitration if the patent happens to be registered in South Africa, or indeed many other parts of relief. So one may wish to either have inter partes obligations, mandatory injunctions on certain things needing to be done on the recipient party, or concentrating on financial damages, etc., rather than other kinds of relief. So that's just a quick explanation. It's complicated and variable, but it's very important to be vaguely familiar with the rules.
That was very insightful. Thank you, James. So now I'd like to move on to a set of questions to talk about a range of issues that you may encounter once an IP arbitration does arise. And Ben, I had a question for you because you've recently been involved in emergency arbitrations, and at the outset of a dispute, or even throughout a dispute, parties may need to resort to emergency arbitration or seek interim relief on a very expedited timeline. So I was wondering, what are some key considerations to bear in mind when dealing with emergency arbitration in the specific context of IP arbitrations?
Thanks, Sarah. So yes, I did an emergency arbitration last month, which was in the tech sector, but actually it wasn't really an IP case because the dispute was all about a shareholders agreement, and the industry they were in was sort of irrelevant. But I have done emergency arbitrations that have involved IP issues, and I'll give an example in a moment. But really, the main issues that arise with emergency arbitrations in the IP sector are the same as in any sector, in the sense that they concern the fairness of the process and what you do with the decision at the end of the day, assuming that this decision is in favor of the applicant. The fairness of the process can be quite tricky sometimes, and when one sits as an emergency arbitrator, one has to think very carefully about what steps can be taken to make the process fair. Remembering the particular characteristics of emergency arbitration, which are that things have to be done very quickly. It is by definition an emergency situation. But one side is always going to be at an advantage because they've had a head start, and you have to still do everything on an inter-parties basis, meaning you have to have both parties involved throughout. So by way of an example, the case that I was going to refer to was a case about a television service in China, and there was a joint venture about concerning this television service, and I was appointed as the emergency arbitrator. And it was plain that the applicant party had spent quite a bit of time and money preparing this case, and had also had a very well-known law firm in a particular Asian country representing them, and with a very large team. In fact, when the hearing happened, they turned up with 12 lawyers on one side. But on the other side, the respondent side, the responding company was plainly underprepared, wasn't really on top of everything by the time of the hearing, and they turned up with one person on their side. So that there was quite a marked inequality of arms. And sitting as an emergency arbitrator, you have to be careful that each side does have a proper opportunity of presenting their case in the particular circumstances you're at. You can't accelerate it. You can't slow things down too much, because that would be prejudging it and avoiding the emergency issue, or making it impossible to give proper relief for the emergency situation. But on the other hand, you can't do it too quickly, because you've got to give the poor respondent an opportunity to present their case. I remember another case which was not an IP case, it was a supply chain issue, and the applicant party in that case filed 10 leave march files at the beginning of the emergency arbitration, and said to the other side, read this, we'll have a hearing tomorrow. Which I felt was a bit like a mugging. I was the emergency arbitrator in that case again. Of course, the flip side of having a tactic like that is that it sort of undermines your argument that this is an emergency situation, because if you've had so much time to prepare the case, then it sort of suggests it's not actually an emergency. So that's the first main issue. The second main issue is, what are you going to do with the decision once you've received it? Because emergency arbitration awards are not recognized throughout the world. Different countries have different attitudes to them. As people might well know, emergency arbitration awards don't naturally fall within the New York Convention, and therefore the system that is available for the enforcement of final arbitration awards throughout the world is not really applicable to emergency arbitration awards. There are some arguments to say that it does count as a New York Convention award, but the more commonly held view is that they are more like interim orders, more like interim measures issued by a tribunal. And various countries throughout the world have taken very different views on whether they are enforceable. And therefore, you have to be careful when you go into an emergency arbitration that you end up with something that is enforceable at the end of the day and that can be useful at the end of the day. In fact, the television service emergency arbitration I referred to, I believe, although I didn't obviously follow it myself, but I believe that they couldn't enforce it in the particular country that actually that was in China. I'm sure I could say that they couldn't enforce it in China. So one wonders what really the benefit was for applying for that emergency arbitration in the first place.
Very interesting. I think I'm hearing some echo. There you go. I think one common thread that we're seeing in your responses in our discussion so far is the challenges that arise from the cross-border or international nature of the disputes involving IP rights. As Simon mentioned, when describing the general trends, these IP disputes may be international. And James also explained the complexities that arise when you deal with jurisdictions' different approaches to arbitrability. And then you just told us this really interesting story about dealing with various jurisdictions too. So I'd be curious to hear from the other members of the panel, maybe if you have any examples of IP arbitrations that sprawled various jurisdictions, and if you had any specific difficulties, and if so, how did you deal with them? So I guess I could address the question to Luciano or Simon. Either of you want to take this question?
Who's first? Okay, should I?
You go first.
It's okay, yeah, no problem. I mean, one of the issues that comes to my mind was quite a tricky confidentiality issue I had in connection with a case which arose in connection with subsequent M&As. And M&As in our industry are quite frequent, okay, due to the business upcycle and downcycle in the petrochemical industry. So the case involved two independent companies acquired in subsequent times, which have acquired in subsequent times a license to operate under the licensor IP rights for a similar technology, but not exactly the same configuration. Then after a few years, one company has acquired the other company with a share purchase acquisition. Then under the older license agreement, the one granted to the first company, certain confidentiality obligation had expired. And this was quite tricky because this could mean that the company holding the first license was able to disclose some of the technical information to the sister company, which triggers an exception of confidentiality, or could have triggered exception of confidentiality under the more recent license. And the fact is that attached to this confidentiality obligation, there were some payment obligation. So you see that this then has become an actual business case. And this is a tricky case also for the licensee, because if the licensee, let's say, which is the same group of companies, decides to make such a disclosure, it doesn't want to commit a material breach of the contract, because that material breach of the contract in disclosing the information, which it determines to be non-subject to confidential obligation, this may lead to the termination of the license, or at least of an action of the licensor to terminate the license. Added to this scenario, the fact the substantial amount of the data relating to these two licenses were still in paper copy, okay? Because these type of agreements have a very long time horizon, okay? They're very large project, there is a very long lifespan of the plant. And all of these dramatically slow down the review process of the entire matter. So how do you tackle this situation? And this is interesting because both the licensor, the licensee have an issue in determining how to tackle the situation. And in the end, what a modern legal department should be able to implement in-house is a record management governance. Is record management governance, in the end, it means to identify, segregate, ranking the information. The second step is to educate your business client to implement this record management governance system, to manage the contracts, of course, and the connected communication. And quite simply, this lays down the cornerstone of any dispute, which is the evidence, which is the most important element to be successful, both in the case, whether you are a plaintiff or as a defendant. To cut short a long story, in this case, we decided to settle ultimately, because in the end, it was ultimately too complex. Even though the parties had agreed an arbitration agreement, it was deemed more appropriate in the end to not go that far, and we decided to settle.
Yes, settlement is part of a tool of options that you have at your disposal. Simon, did you have anything to add on? Any other stories or cautionary tales?
I suppose not really cautionary tales, but I think it goes back to the issue of the international nature of often some of these disputes, and trying to reconcile people's different experiences of their legal systems, and making sure that those are aligned with the arbitration, as particularly when you start the arbitration, making sure that the framework is agreed and everybody understands that. And one a particular example is one where I was involved, whether it be a US entity and an EU entity, and very different discovery of attitudes in terms of discovery and disclosure. In the EU, as you know, disclosure of documents in litigation is fairly limited in some situations, whereas in the US it's not so limited. So it's reconciling those two aspects. But in other situations, I've found it not such a problem. Particularly we had a patent dispute. It was very useful to the patent lawyers in the US, on the same page as the patent lawyers in the UK. So we all agreed that in this particular situation, that it was necessary for a site visit in the UK for the arbitrators. So there were 3 arbitrators, and to make sure that they were particularly appraised of the technical issues in the case, and so we had a site visit where they could go and visit the factory in question, and that helped them understand the patent process that was the subject matter of the arbitration. So that was something that was good. And I suppose the other issue is venue and the seat of the arbitration. Again, making sure that can be agreed. So often that's agreed in the contract, which has the arbitration clause, but sometimes it isn't, and that can cause some issues. And often find a neutral territory has to be determined. I've had a situation where we had a US and an Indian company in an arbitration, so we agreed on Geneva, in fact, as being the neutral venue. So that was a happy, but better for us, because the flight times from London to Geneva are not as bad as the US or India to Geneva.
I can imagine that. So I want to piggyback on a point that Luciano, you raised. Obviously, evidence is crucial, and in particular in IP arbitrations, you may have to deal with complex and technical evidence because of the nature of the underlying subject matter. And so I wanted to ask maybe James, how do you develop and present that technical evidence, bearing in mind that your arbitrators may or may not have relevant technical background? How do you work with experts, or how do you deal with the subject matters?
Yeah, thanks. Well, half of the problem is resolved if you have arbitrators, if you've availed yourself of the opportunity in international commercial arbitration to have arbitrators who understand the issues. But then you still have a remaining problem with those arbitrators in order to explain to them what they should do in order to help you win. Otherwise, it may be a double problem where you may, and this does happen, of course, very regularly, have an arbitration which involves IP issues with which they're not familiar at all, and it could get very complicated. It sort of exacerbates a problem that pervades in arbitration generally if it's complex. Excuse me. I would start off with the importance of controlling experts. Ideally, you'll have a tribunal which will be interested and involved and have experience of how to get the best out of experts. From the beginning, in my book, it called out for a situation which is a bit of an example of process in the Technology and Construction Court in England and other places, where we're talking about expert issues being defined in advance, expert questions being defined in advance, joint expert reports being provided with a collaborative input as demanded and determined by the tribunal. So the experts don't pass in the night, because if you've got a fiendishly complicated matter where both experts are producing enormously impossible to understand complex things in order to help their side win, that doesn't help the arbitrators at all. They won't end up understanding anything. So that should be managed from the beginning with the tribunal and the assistance of the parties. The tribunal should be assisted in being somewhat interventionist. So, for example, these are random examples, but for example, proposing and procuring that opening statements, skeleton arguments, etc., address certain things very specifically is important. There is a suggestion and a good practice where one can propose to the tribunal that there is a specific session or sessions, a bit like voir dire in trial in the United States, but to the tribunal to frame complex issues if they're not familiar with it. And certainly there should be use of demonstratives, increasingly impressive and important in international arbitration, and more important in this process than ever. There is the possibility of having the experts go first, which rather turns around, I'm talking about in the merits hearing, rather turns around the process from the normal sequence. But if you've got a tribunal that needs to be helped on the expert issue, on the complex patent issues, they may benefit from understanding the expertise before they hear the witnesses, because they don't really know what the relevance of the witnesses is to the nub of the issues in dispute. And then there could be hot tubbing as well. So that's my sort of laundry list of possible ways of dealing with helping a tribunal.
Thank you, James. So now perhaps we can move to a different category of questions, focusing more on damages and enforcement in the context of IP arbitrations. And perhaps, Simon, could you explain to the audience what are the forms of relief that are available when you're arbitrating IP rights, and how does the relief that you seek inform your strategy in the arbitration?
Thank you, Sarah. Well, I think it sort of does depend to a certain extent on the governing law that's agreed. But if it's English law, which is a common governing law to agree on, there are quite a number of different options in an IP damages context, and that goes back to a series of cases concerning damages. And in fact, there's two main strands, and that is damages or counter profits. Damages being sometimes important when you're looking at situations where the claimant or the applicant has lost sales due to an infringing situation or due to a breach of a license or an agreement. you might want to be compensated by damages for the loss you have as the applicant you have suffered. But it may be in other situations that you find that the respondent or the defendant has profited quite substantially from the breach or the infringement, and in those cases you might want to go for what's called an account of profits, and that's a remedy that's certainly available. I would say though it's net, it's not gross profits, unfortunately, for the applicant, and there are various rules in which govern how that sort of is calculated. It often needs quite a lot of complex, going back to the experts issue, in these sort of situations, that often requires quite a lot of complex accountancy evidence and financial information, and that you often need experts to present that to the tribunal, and that can be quite a complex issue. But those are the two main strands that are available. But there are other types of loss and types of damage that can be awarded in addition to that, and that also includes things like what we call springboard damages, where you have a situation where, because of the infringement or because of the breach, the party that's made that breach or made that infringement has been able to get a bridgehead in the market, which has enabled it to sell additional products or additional services as a result of that breach. So it's sort of had a knock-on effect, and that sometimes that sort of damage is recoverable. There's also the concept of flagrancy damages. So in situations where particularly an infringement there's been an infringement which is particularly egregious, or has been done in a way that's in some ways harmed the reputation of the claimant or the applicant in ways that aren't necessarily measured on a balance sheet, but at the same time there is some sort of loss there. Certainly in the UK and under English law, we have the concept of moral prejudice, and that comes under the head of additional damages, and that sometimes is possible to claim. What I haven't touched on, I suppose, is sometimes the most important thing in an IP infringement, and that is the injunctive relief that a party may be seeking as part of that arbitral award. And if there's consent from the other party, and then obviously that could be a key element of the relief that you're seeking. But it may not be necessarily that, and particularly in a licensing situation or a franchising context, you might be looking more for damages or the profits. So I mean that's a sort of it in a nutshell. There's obviously a lot more to it than that, but hopefully that gives you a bit of a flavour for the sort of types of relief that are available.
That was very helpful. Thank you, Simon. Maybe turning to you, Ben. So as Simon explained, given that the injunctive relief may be an important aspect of what you seek in an IP arbitrations, let's say you've successfully obtained it, are there any key considerations to bear in mind when you're trying to enforce it? And you kind of alluded to it already in the context of emergency arbitration, but I wanted to broaden the scope of the discussion to let's say the injunctive relief, like let's say at the end of your long dispute.
Yeah, so I mean, the problem with injunctive relief sometimes can be what happens if it's not complied with. And some countries of the world will allow you to obtain a court order to support the injunctive relief you obtained through arbitration. Therefore, a breach of it will result in a criminal penalty. Other countries won't allow that, and you've then got to have a fallback. and I've seen a few fallbacks in the world. I mean, I've seen a fallback whereby an applicant applied for injunctive relief and asked in the alternative for an amount of damages that represented a notional amount which of loss caused by the failure to comply with the injunctive relief. So there would be a monetary fallback if it was not complied with. Another fallback is actually simply using it as a injunctive relief as a declaration of rights, and having that as almost a stick to beat the other side with, and perhaps you might be able to register it some place. Perhaps at least you'd use it for publicity purposes. I mean, there's it can be a little bit tricky actually to enforce injunctive relief, and you need a strategy before the end of the arbitration, before you start the arbitration, about how you're going to enforce the injunctive relief once you obtain it, if you do obtain it. I mean, the same is true, of course, of any arbitration award to some extent. I mean, there are, although the New York Convention does allow for the enforcement of awards throughout the world, there are various peculiarities in some countries in the world which you need to be aware of if you're going to enforce an award there. So it's very much a matter of knowing your enemy and knowing where you're going to be able to enforce, where you will have to enforce your award, and whether there are any peculiarities in that place that you need to take into account before you obtain your award.
I got a question for Ben.
Sure.
Was there an objection to the first example you gave, the one about giving an idea of damages if the injunction wasn't ordered? Was the response from the other side, well, hang on a minute, because injunctions are only meant to be ordered if that damages isn't an adequate remedy anyway. So that's a reason why you shouldn't have an injunction, or not, I don't know. Especially if it was earlier rather than later.
That example did come up in the case about the TV service I referred to earlier. I have done other cases, it must have been Orrick, but I'm coming back to the same case again, but that was raised in that particular case, and it was sort of objected to by the other side, but the other side was pretty hopeless. But at the end of the day, I didn't grant it because I wasn't convinced that I had the power to grant it. On the other hand, I am aware of it being granted by emergency arbitrators under the SEC rules. There have been instances where emergency arbitrators have granted an injunction and in default of that an amount of damages for failure. Sort of, it's a fine, but a penalty for not complying with the injunction. So it's very country specific, and it's very. I think it depends on particular cultures, depends on particular remedies elsewhere, perhaps in the court system. So it all depends is the answer to that.
Ben. And I guess one other question on damages would be shifting gears to the monetary form of relief that you may obtain from an arbitration. Luciano, I'll address this question to you. What would you say are the greatest challenges when you're trying to quantify damages with respect to IP arbitrations and turn that into a monetary sum? And how would you address those difficulties?
Yeah, I mean, linking to what Simon just said, I mean, generally speaking, the two major remedies are account of profits or damages. And in reality, in most of the cases, when the economic result of the arbitration becomes apparent, the parties will agree a settlement before the arbitration tribunal issues the award. Nonetheless, the quantum of damages in the end it becomes really a combined commercial and business finance effort. And as you have probably already understood from Simon's explanation, the difficulty lays in the fact that this is a prediction. You have to make a prediction of what profit you will lose, what you have lost if you had done something. Or what ancillary sales, for example, of tied products, which are technically compatible with the technology which has been licensed, how many of these sales have you lost? if you had licensed to that infringer, what is the reasonable royalty that you would have asked? So all these are predictions. And what you need to do in this case, what we do in this case, is to identify, first of all, the market. So is there a global market for that process, technology, or product? Is there a regional market? And in this market, we try to determine also what are the shares, what is or what would have been our pricing policy in that market. The difficulty is also that you cannot rely on, let's say, industry norm, because unless we're talking about products which are publicly marketed, there isn't an industry norm, for example, in the technology licensing business, because the prices, for obvious competition law reasons, they're not obviously shared and they're not publicized. So what is necessary to do to address this point is an assessment of the economics, so a market analysis, and a meticulous accounting of the cost, recording all the commercial data. And then you measure your IP value, which is established in a set of documents, in tax filings, statutory accounts, in transactions. But the aggregation of all this data, you obtain, in the end, you carry out a calculation, okay? And this needs to say that this requires a sale and accounting personnel which is competent in the technology business, because not all the professionals in sales, licensing sales, or let's say sales connected with IP rights, so conditional sales, or finance professional, they're not all the same competent in understanding the peculiarities of a technology business.
Thank you, Luciano. I think now we have a couple minutes left for the event, so and we got a number of questions from the audience that I'd like to direct to the panelists. We'll have probably time for one or two. The first one is regarding Jay's comments on arbitrability of patent validity or infringement disputes in various jurisdictions. And a member of our audience noted that an attractive workaround is to select a welcoming arbitral seat and provide that all disputes will be resolved under the law of a single jurisdiction, which perhaps is not a perfect solution for enforcement, but it allows for a single arbitration to resolve disputes worldwide. I wanted to ask the panelists, have you seen this approach used? What are your thoughts? Any reactions?
Well, briefly, if it's talking about, that's Gary, so thank you, Gary. If it's talking about a post-dispute submission agreement to arbitration in order to resolve things in one forum, yes, once. I've seen it wanted by one side and not wanted by the other side a lot of times, because generally there's an asymmetrical imperative set between the two parties. So one wants to have it resolved everywhere and the other one doesn't. That's my view.
I've had some experience where we've resolved the patent liability issue, and there's a question of damages. So in some ways that was a workaround, because we didn't have to worry about validity issues or infringement issues that can be treated very differently depending on which country you're in, and that was done so in fact it worked out quite well. So it was looking at the arbitration was just looking at damages, and that was done according to sort of international accounting standards. So that was I suppose a workaround in that respect, and the English law was chosen as being the law that would govern how damages would be calculated.
Great, thank you. And the next question from the audience, Has the panel arbitrated any disputes involving breach of intellectual property rights using the Court of Arbitration of the European Chamber of Digital Commerce? And if so, would you encourage the use of this forum on the right case?
No.
I'm afraid not.
I'm afraid not, indeed.
Or perhaps we can broaden this question and talk about different arbitral rules, venues. Do you have any experience with certain set of arbitral rules that you favored over others, or any considerations when choosing the seat of arbitration?
I think I can partially answer to that from an in-house counsel perspective. In the end, when it comes to the drafting of arbitration agreements, arbitration institution, the most important ones like the ICC, or the London Court of International Arbitration, Singapore International Arbitration Center, they do recommend their own version of arbitration clauses. However, you must pay special attention to at least two important elements. The first is the seat of the arbitration, because it has the greatest potential impact out of all the elements of an arbitration clause. This is due to the fact that the courts of the seat of arbitration can make the ruling that can fundamentally affect arbitration, for example, about the tribunal's jurisdiction or not. And the second element is the consistency between the seat of the arbitration and the choice of arbitration rules, because a local arbitration institution is often best placed to identify the proper arbitrator, in the reason. So these two elements I take greatly into account in the drafting and the choice of the arbitration institution as well. I would not go for arbitration institution, for example, in jurisdictions where there is not sufficient substance in terms of case law in relation to the business in which I'm interested, because in the end there is not sufficient material to elaborate to achieve a balanced solution by the panel. You will be a pioneer in that case, and let's say this ultimate judgment may be a bit unpredictable.
Thank you, Luciano. And I'll squeeze in one last question, because we've talked about so many different complexities and challenges to take into account. And to me, that translates into the potential to incur a lot of costs when dealing with IP arbitrations. And I'd be really curious to hear your perspective on how do you manage these cases efficiently to make sure that you control costs, given that that's also a consideration to bear in mind when you're dealing with these sorts of disputes. And I'll open the floor to anyone who has any great insight to share.
Well, in my experience, usually the best way of controlling any costs is to actually work out what the dispute is about in the first place. I mean, and and set that out very clearly, and have a very clear list of issues. I mean, I regard a list of issues as the single most important document in an arbitration, because one sees all these arbitrations where the parties, the experts, all the participants really don't know what the case is about, and their submissions, their evidence, their everything else just balloons because there's no real discipline to it. And arbitrators, I've also seen arbitrators who have allowed the parties to do this very often because the arbitrators themselves don't really know what the case is about, and they're afraid of appearing too interventionist, or they just can't be interventionist because they don't have sufficient knowledge. So I always say we have to have a good list of issues at the outset.
Yeah, which is not easy, I'd say,
no.
to obtain also for the in-house counsel. And I got to say that here the in-house legal department, however, plays an important role, to get the best possible picture of what are the evidence available for both the pleading phase and the hearing phase. And the documentation, in the ideal world, everything is classified, identified, etc. That's not, we know that's not the reality. Or to get to that reality, and today is possible in our digital world, that requires an investment. So it boils down to the fact how much a corporation wants to invest in the end, getting up to date, if not real-time data that it could use in the potential of a dispute. And is an administrative cost. And you know, many organizations are a bit more allergic to these costs than others. In the hearing phase, however, that is probably where you can get a better control, because in the end, if you are able to well educate your technical experts, which are called to witness, then in that case, probably you can do, in the end, you can somehow in the end control the extent and the timing necessary to obtain the witnessing. But indeed, is never possible in the end to get a precise figure up front.
Thank you. So I think that brings our conversation to an end. I'd like to thank all of the panelists for your time and your invaluable insight today. It was a real pleasure for me to be moderating and being part of this conversation. And I'd also like to thank the audience members for joining us today. I hope to see you, all of you, at future SVAMC events. Thank you.
Thank you.